Thank you, sir. I rise to support the Bankruptcy and Insolvency Code Amendment Bill 2019. I can say that this is one of the biggest reform of the century, and this is a reform visualized by our Honorable Prime Minister Narendra Modi ji. We have seen that before coming into force of Insolvent Bankruptcy Code, numerous remedies were available for the companies, for the individuals, for the firms, either for the redressal of their grievances, either to approach before the AIFR, BIFR, under the Companies Act, and before the DRT, Surface I, and for the labor to approach before the labor court, and also for the recovery to file the recovery suit before the civil courts. And in some cases we have also seen that for redressal of the grievances, the aggrieved has also approached before the High Court under Article 226 of the Constitution of India. And we have also seen that in these proceedings the interim order was granted, the government money in crores was stuck, and everybody was in trouble because there was no resolution and no scheme was provided. And it has also been contended by some of the honorable members that in case of the provision is also there under the SEBI Act and RERA. So looking to the scheme of the Insolvency and Bankruptcy Code, in case of conflict between IBC and SEBI, and in case of conflict between IBC and RERA, the IBC will have an overriding effect. Now we have seen that in view of the fragmented law, because numerous number of remedies were available and everybody was approaching as per its choice in various courts. It may be a SICA of 1985 Act, but we have seen that it failed to produce desired results. And it created a protective wall. And on account of this, even the perpetual control of the management, despite the fact that the company's mismanagement was there, the possession and control could not be recovered by the financial creditor, and it was one of the biggest problems. And in view of the consequential effect was that before coming into force of the Insolvency and Bankruptcy Code, we shall be in position to recover only, the recovery rate was only 26%. And it is very strange to see that around 9% was the cost of resolution. And if the delay part we see it, huge time was spent in the litigation, and the delay of every time, this average time taken was 4.3 years. And despite this, there was only a suboptimal realization of liquidation. So that was the reason that all this fragmented law hampered the ease of doing businesses. Sir, so far the Surface Act is concerned, it was basically during that time the focus was on the recovery of debt and liquidation, and there was no resolution provision was there. Sir, I would also like to make it clear, way back in 1960, the Law Commission report, the Law Commission of India made it specifically clear for bringing Insolvent Bankruptcy Code, and such type of law is need of the hour. Since 1960, nobody had taken the pain, and first time in 2014, this Honorable Prime Minister Narendra Modi ji, it is vision of the Prime Minister that this code was enacted. And if you see the other countries and the realization under this code, because this code is always there in America and other European countries, and we have seen that because this is already there for last so many years, the realization is around 90%. But in our country, as on today, the realization is not to that extent, but it is around 50%. But in coming years, because these old NPAs are there, so that's why this is the reason that the realization is less. And if you see this, because what is the region? The region is since 1950 to 2006, around 18 lakhs crore loan was advanced, and during 2006 to 2014, and it was raised to 58 lakh crore. So on account of this basically the financial creditors were in doldrums, and we have created the ecosystem of the debtor paradise. And this is the reason that the Supreme Court has recently taken the view, when the validity was assailed before the Supreme Court of the Insolvency Bankruptcy Court, and the observation of the Supreme Court that this is the end of the paradise, defaulter's paradise. So we see that the IBC is basically to consolidate and amend laws, and basically for reorganization and insolvency resolution in corporate, in firm, and in individual. This is a basic, it is also provided a time-bound manner. Now the time provided is, maximum time provided is 330 days by this amendment also, and the further it is extendable up to 90 days. So this is with a view to maximization of the value of the asset, and it has also provided this formation and constitution of the IBBI board. And kindly see, the IBC, if we see the IBC and the earlier law, it makes it clear that it provides the resolution, whereas the earlier law deals with the liquidation. And it provides the rescue, where the earlier law was intended and object was for the recovery. So by this act and by this IBC code, the problem is minimized. And we have asked, under this IBC code, the waterfall is also provided, the waterfall mechanism also there. The financial creditor as well as operational creditor, the losses, they are fairly distributed among creditors. And in the World Bank, ease of doing businesses for India has tremendously improved on account of the coming into force of the IBC, because the realization is more. So after coming into force of the IBC, we have seen it has a deterrent effect. So realization is in so many fold. So on account of the coming into force of the IBC, what happens, even before filing an application, the complete ecosystem in the economy has been created, and it is basically earlier the debtor is required, earlier the creditor is required to run behind the debtor, now it is vice versa. And on account of this, the large number of money has been deposited. Sir, this party's time is around 1 hour left. Only I will take 15 minutes. I will not take more than 5 minutes, sir. I will finish in 5 minutes, sir.
No, please.
I will finish in 5 minutes, sir. Before the NCLT court, once the application is filed, in large number of cases we have seen the amount have been realized. After admission of the application, the amount has been realized. And so many cases have been resolved under the IBC and before the NCLT. So far the working of the NCLT is concerned, we have said fairly it is working well, and we have seen that the large number of employment have already been made, and the amount is around this realization before the NCLT and at the time before admission of the application is around 3 lakh crores have already been realized. Now, so many cases have been transferred from the earlier courts to NCLT, and some fresh new cases also filed. So the disposal rate is fairly good in comparison to other adjudication system. The provision of the financial creditors, the resolution plan and resolution professional, this is also working well. And in case of only in case where the resolution plan is rejected, then it can go for liquidation, not before that.
Chaudhary, please.
So earlier to amendment 2018, only 2-3 minutes, sir. So because we have amended 3 times, and earlier the provision was there. Earlier the promoter was required to participate, and that has been he has been removed. And on account of this, because we have also seen the particular company was having the asset of 10 crores, they have advanced the loan to 900 crores, and we shall in portion to record only 53 crores. So all these NPAs and bad loans are during the period 2006 to 2013.
Please.
And so far the MSME is concerned, the relaxation has already been granted in second amendment. And for the home buyers also, earlier they were not the financial creditor, but they are now the financial creditor.
Covered, please.
And so, just 2 minutes, sir. And so far the bill of 2019 is concerned, this is amendment only for the purpose of clarity and interpretation, because the various courts and NCLT has given the this various interpretations. So with a view to remove any ambiguity, so this for the purpose of clarity and interpretation, and with a view that the provision of the IBC may not be diluted, so therefore these provisions are there before this one, and this has been done after consultation after consultation with the various stakeholders and with this observation, I support
Thank you.
the bills.